My children are older teenagers. They live with me full time. Dad is supposed to have them 2 days a week, but due to his living situation, he can't take them. He's more than welcome to take them out for dinner or a movie or whatever, but if they can't go to his house, but again, he never comes. It has been this way for 4+ years. Regardless, he does talk to our youngest on the phone on a regular basis, and he knows what is going on in their lives. I got engaged a few months ago, and my fiance plans on moving in when his lease ends May 2024. The wedding is February 2025. We have been together for over 4 years. The kids know him and like him. He helps with driving the 2 younger ones around. He goes to school events. He comes over and he and my son scream and yell and play Smash Bros and Mario Kart. He often stays the night. The kids think nothing of it at this point. My oldest tells him to just move all in already so she can steal his fluffy cat. I filed for full custody and with unlimited visitation to dad at the children's availability due to their school, extracurricular work, etc., but for him to have no overnights. I'm really just looking for the court paperwork to reflect what we're actually doing. I've asked my ex to sign and agree to it since that's what we've been doing for 4+ years, and it's what the kids want. And instead, the ex filed with the court to try to put in a clause that says that my boyfriend, fiance, girlfriend, whatever, cannot move in or sleep over unless we are married. I think this is crazy. I know he can file whatever he wants to, but will a judge even entertain the idea of this clause? I don't even know why he cares all of a sudden. He's known about the fiance for a few years. Hi, my name is Billy Tarasio, Arizona family law attorney, and I appreciate your question and all of that detail, and I can also appreciate your frustration. Your question is, will a judge, under these circumstances, really add a clause that says you're not allowed to have your fiance spend the night at your house? And the answer is no. No, no, no. The judge is not going to tell you that you cannot have your fiance spend the night at your house. That is your call. That is your decision. There is nothing that presents danger to the children unless you believe that somehow the immorality of your choice is not in the children's best interest. But that is your decision, because we live in this free country where you get to make choices about who spends the night at your house as long as they are not dangerous to your children. I would bet that their dad comes around. And if not, your case is pretty strong. I don't like taking cases to trial because there's always risk. So it would be nice if you could come to an agreement. But if you can't come to an agreement, your position is reasonable. It's backed up by the facts of what you all have been doing. So I would say you want to gather all of your evidence. And then maybe consider what is gained by filing. So you already have what you want. So if you were talking to me, I would really talk through the pros and cons of moving forward, what changes, if anything. It's on him to enforce his court order time, which includes overnights, but he doesn't because of his housing. We don't know what that means, but I would just encourage you to really think through this before you make whatever decision you make, and know that however it turns out, you're going to be okay. And congratulations on your engagement and your upcoming wedding.